Hello, guys. Naija Street Lawyer is back again. Recently, we saw the horrific sight and terrible death of a young man who was mauled to death by dogs in an estate in Lagos. May his gentle soul rest in perfect peace. And my condolence to his family, friends, and those who know him, because he has friends, he has family, members of his family. What a sad and terrible way to die. A lot of people have left different opinions, raised different opinions. Some have even said that the owner of the dog will be tried and will go to jail. But unfortunately, there is no criminal liability as it stands today that makes the owner of the dog liable for the death of another. In 2019, following the discovery of a lion, a cub, I think about a few months old cub that escaped and was found in the streets of Lagos, which was later sedated and then taken into custody. The Lagos state government then, through the Attorney General, made statements that the Lagos state is considering enacting a law that will criminalize those who criminalize ownership of dangerous animals, maybe particularly when they have caused harm to others. But to the best of my knowledge, that law was not passed. For those of you who are in Lagos who follow legal trends, if you think the law was passed or you know that the law was passed, please draw my attention. I've not seen that law. My research does not show that any of such law has been passed. So in Lagos State, there is currently, as at present, no criminal liability. However, there are civil liabilities for keeping dangerous animals. There are actions that someone can bring against the owner of a dangerous animal that attacks you. That is to say, if someone's dog attacks you, you can actually lay claim, you can bring a claim in court. And the action are in two folds. We have one called scienter action in law. Now, what does scienter action means? It means knowledge that this animal has the capacity to cause harm to others. And this action is in two categories, or this law is classified under two categories. One of them is the one that covers for animals who are naturally known to be wild and dangerous. Such animals, the liability is, there's a strict liability on the owner. For instance, those who keep lion as pets in their homes, dangerous snakes like, let's say, python, elephants, and all that. You know that naturally these animals are dangerous. They are dangerous to humanity. They can harm humans. If you keep such animals and they harm someone, there is a strict liability on you. It doesn't matter whether you knew it could harm or not, because everyone knows that these animals could harm someone. Now, you remember that some people keep these things as pets. Now, if you choose to keep these animals that are naturally known to be harmful to humans, when they harm or hurt humans, then you are strictly liable. There is no defense as to I didn't know. Then the other category are animals that are, well, not naturally dangerous. All right? Naturally, they are not dangerous, but they have the capacity to constitute danger to humans once in a while, you know. For instance, one of such animals is dog. Or whatever animal, even cats. You know, naturally they are pets. They are kept by humans as pets. So they are not known generally to hurt humans. But you and I know that there are species of dogs that are known to hurt, that would hurt humans. Or even dogs, even the local dogs we call kere, they have the capacity to chase people and bite them at times. You know, so in such case, the position of the law is that the owner of that animal should have known. All right. If you can prove that the owner of that animal knew that the dog has that capacity, then the person will be liable. What do I mean? For instance, if I have a dog and that dog beats someone, Like it could be a defense that I didn't know that the dog could hurt someone. If that dog has never hurt anyone before or has not shown that tendency to hurt someone, it is not enough to say, oh, my dog has never hurt anyone. But then my dog goes about chasing people, attempting to bite them at all time or different times. Now, if the person bringing the action can prove that, yes, this dog has not beaten someone before, but it has behaved in such a manner that anybody can tell that this dog was going to bite someone, then the owner of the dog would be liable. Now, coming to the case of this young man, first, there is a defense that those who do certain jobs that expose them to such dangers cannot claim under scientific action. Now, the reason is simple. If you work in a zoo, you already know that naturally you are exposing yourself to risk and that these animals can harm you. Now, if the animals harm this person, harm someone, or the person who works in that capacity, you cannot claim under scientific action because you have consented to work there. Okay, volunteer non-fit injuria. Okay, you have consented to work in that office, or sorry, in that capacity where you are exposed to such risk. So that is a defense to the owners of the animal. Now, it is important to point attention to the fact that it doesn't matter that your dog strayed out of your compound and beat someone. If your dog strayed out of the compound and beat someone, you are liable. Don't say, oh, it is not in my premises. It doesn't matter whether it is in your premises or it's not in your premises. But it is a defense whereby somebody trespasses into your premises where you have such animals, where you keep them safely, and then the person trespasses into. The person is a trespasser. The person cannot bring an action under scientific action. Now, let's drive home the point of voluntary non-fit injuria with the case of the young man in Lagos. Remember, I said that those who work in certain places where they are exposed to such animals have consented and therefore cannot bring an action under, or cannot maintain a claim under scientific action. Now, the case of the young man, I hope he doesn't die in vain. If those dogs are used as security dogs in the entire estate, in the estate where he works, and he knows that these dogs are security dogs in the estate, and he's a security man, he cannot maintain an action because the defense of voluntary non-fit injury would avail the estate management, because as an employee, a security guard who works with these dogs, he knows that he's exposed to being beaten or being mauled by these dogs. Now, that is the situation. But where that is a privately owned dog by a resident of the estate, and he had not jumped into the premises or trespassed into the private premises of the owners of the dog, he can maintain this action. It doesn't matter that he's a security man, because he did not consent to being mauled by those or working with those dogs. It is privately owned by an individual. Now, aside the scientific action, there's also, of course, negligence. You can bring an action against the owner of a wild animal or a dangerous animal in negligence. Now, if the scientific action fails because you couldn't prove that this animal or this dog specifically has the capacity or has shown tendencies to hurt humans in the past, and your action fails under scientific action, then you can maintain an action in negligence. The duty of care. The owner of a dog owes the public, passers-by, the duty of care. And then the duty of care was breached by the fact that that dog beat the passerby or the person. Remember, I said trespass is a defense. Even in negligence, trespass will be a defense. If you trespass into somebody's premises and you are beaten by a dog, then the defense would also avail the owner of the dog. That is why you see people writing, beware of dogs in their premises. I'd like you to like this video, leave your comment, respond to comment in the comment section, and share. Thank you very much.